wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Waalaikumsalam.
Today's I think internet coverage is not so good because it's heavy raining here in KL. Is it raining at your place? Oh, ni semua kat rumah ni.
Yes.
Yes.
So maybe probably we got cut off along the way, so just bear with. Alright, so I believe that according to our schedule here, next week is the semester break, right? So tonight's class will be the, of course, the last class before the semester break, and then it completes. Today we will complete the 7 weeks of lecture, and after the semester break we'll have the. I think I inform you that we will divide this section to 3 groups. I will take one group, and then the other 2 groups will be taken by another lecturer, another facilitator. And 7 weeks after the semester break, we'll do the practical simulation. If you look in to the course outline, practical simulation in the course outline is first interview the client, and then a trial, examination of witness and submissions, and then we have a practical simulation, hearing of application. We have here summary judgment, disposal of case based on facts and law, disposal of case on laws and construction, SS, statements, packet out, pleading, and so many things. So I'm not really sure yet how to do this application, but most probably we will just conduct a practical simulation on the trial, examination of witness and submissions, and that too I still not sure how to conduct this online, how to examine the witness online. So I will discuss with other facilitators. And then just to confirm with you guys, for civil procedure, I believe that you will conduct a hearing of injunction application. And besides that, apa lagi? What else do you actually need to complete for civil procedure?
So far, what have been informed to us is that we only have to do the injunction.
Injunction only for the whole semester.
Yes, kan kurang.
Oh.
Yes, sir. Tak ada task lain lagi.
Okay, and then what are the other subjects besides civil procedure that you take this semester? Criminal procedure,
Conveyancing, probate,
mediation, ADR.
ADR. I see. Okay. All right. So I think most probably we will not do the practical simulation on the hearing of application, because if you do then you are doing that for civil procedure. So perhaps we will do a trial, but to do a trial we need you need to have the pleadings and also all the bundles of documents and also the statement of agreed facts, issues to be tried, and things like that. And you have those statement of agreed facts, issues to be tried, and list of witness. But I'm not sure whether I can use the same case in your civil procedure for our trial. If it is impossible to use that case, I will give you a new case. Okay, I will give to you, each firm, a new case to be studied. Normally, I will give you a reported decision. Then you study the reported decision, the reported journal, and then based on that reported journal, reported case that you've been assigned to, you will have to prepare the witness statement. I mean, you have to identify the witness, and then you have to prepare the witness statement, and then we will do the examination of witness, and also we will do the cross-examination perhaps based on the witness statement. And then after that, you will prepare your final submission based on the reported case. I think that is the best way to do this, because otherwise you need to file your pleadings. You need to file your summons. You need to file your defense. You need to file your bundles of documents. And I don't think we have time for that, because we only have 7 weeks. Okay? So we'll see how. I will give a direction after the semester break. For tonight, firstly, I want to give my comment on your statement of agreed facts and also the issues to be tried, as well as the list of witnesses. Some of the firm, okay, file betul, but there are firms which file the statement of agreed facts without intitulment. You know intitulment, right? The title of the pleadings dalam perkara mengenai dalam Mahkamah Tinggi Melaya di Kuala Lumpur, and then guaman civil nombor berapa, antara plaintiff siapa, defendant siapa, that one is missing. Some of the firm did not state that. What is the intitulment? Okay, you aware that? You aware, right? We call it intitulment. So the heading of your pleadings or your documents filed in court, you must have intitulment. So please, for the documents that you need to file after this, you need to have the intitulment. Number one. Number two, some of the firms just consolidate all 3 documents into one document. You ada heading, and then you buat statement of agreed facts, and then sambung bawah the issues to be tried, and then you continue with your list of witness. That is wrong. Okay? When I mention 3 documents, it means 3 separate documents, not 3 documents in one continuous document. So you have your statement of agreed facts, whereby you state your entitlement, and then you letak statement of agreed facts, and then whatever your facts 1, 2, 3, 4, 5, and then you will have your signature, the plaintiff solicitors and also the defendant solicitor signature. And of course, before that you have tarikh, the date, and then you have the endorsement as to the plaintiff solicitor who filed the statement of agreed facts. And that is one document. Then next document, you will repeat the entitlement again. You have your entitlement, and then you put your heading, issues to be tried, 1, 2, 3, 4, 5, and then you have your date, and then you have your signature and endorsement as to the plaintiff solicitors. Okay, that is second document. And then third document, it follows. Okay, the list of witness, entitlement, list of witness, and then you give the list of witness. For list of witness, you cannot just put the designation, or you cannot just put the position of the witness. Ada setengah firm letak tulis artikel Facebook, contoh. So that is not the way to file witness list of witness. In the list of witness, you must specify the name of the witness and the IC number of the witness. Okay, and some of the lawyers also state the address of the witness. Okay, you must have the name, you must have the IC number at the very least. You tak boleh nak letak, okay, seorang pengarah syarikat without the name. Cannot be like that. Okay, and for list of witness juga, some of the firms just, put an additional points, put an additional information, which is the purpose of you calling that witness. Okay, for example, letak nama Yusfarizal bin Yusuf, IC number, and then letak pula the tujuan. Okay, to testify on the publication of a defamatory article. That is not necessary. You don't have to do that. You don't have to state the purpose of you calling the witness. Suffice for you to state the name and IC number for list of witness. Alright? So that is the the requirement for to file a list of witness. And then what else? I think some of the firm do it correctly. Thank you very much. But I think still many firms still fail to comply with the standard forms and also the standard requirements. So I will give you a chance if you want to rectify your documents. Okay, you can refile your documents into the classroom. You just withdraw the submission of document. I think there's a button of unfile something, and then you refile the corrected document before the next class. Okay, I allowed you to do that for the purpose of the documents. Right. Okay. This week, I will give you another assignment, which is you need to prepare the bundles of documents. Okay? I believe that your statement of agreed facts and issues to be tried, you have followed your case in the civil procedure case, right? So based on that case also, you need to prepare the bundles of documents. You remember our lesson, the bundles of document must consist of 3 parts, A, B, and C. I don't want to repeat that. So you prepare the bundles of document. The bundles of document will look like, bundles. You will have your first page is your cover page. Alright, the cover page will consist of the intitlement and then the heading. Okay, ikatan dokumen bersama. In English, common bundles of document. Right, and then after that, you will have the address of solicitors. On your left is the plaintiff solicitors, on your right is the defendant solicitors with the address and also contact number if you want to put it. Okay, so that is a cover page. I think I already explained it, I'm just repeating this. Second page will be the index. Okay, so in the index, you put the index lah. Okay, the documents and also the page number. Okay, and then you have the first part, which is part A. You put a divider, one sheet of paper, maybe a colored paper or whatever. You put that part A ataupun bahagian A. Right? So after the part A, you have all the documents in part A. And then you have another divider, part B, the documents in part B, and another divider, a document in part C. Right? I assume that the documents involved in your case is not that much. So you will have just one bundle. Otherwise, if the documents, part A, part B, or part C, is more than, for example, more than 200 pages, say for example 400 pages. So you will need to prepare a jilid. Okay, ikatan dokumen bersama part A jilid 1. And then you have the second bundle, part A jilid 2. Right? And then you have part B and part C. But I think for the purpose of our assignment, you don't have to do that. Suffice with one bundle consisting of all 3 parts. Right? Okay. So, before you file the bundle, I think you remember our lesson, the plaintiff solicitor need to send the draft or proposed index of the common agreed bundle. So the plaintiff solicitor prepare the list, and then you have the column for marking by the defendant solicitor. You put there, mark, buat kolom kosong, the index, numbering 1, first column is number, second column is the document, and then the third column is the page number, and then the fourth column is the marking. Okay, that list need to be sent to the defendant solicitor together with the proposed documents lah. Kan, you have your index and then you have your proposed documents. Send to the defendant solicitor. Defendant solicitor will mark A, B, C, D, E, A, B, C, D. A, B, C je lah, tak adalah D kan. A, B, C, B, B, C, A, whatever. Right? When the defendant solicitor has marked the list, the defendant solicitor also will prepare one list of the defendant's proposed documents. Plaintiff might have their own document. Defendant might want to add another document. Okay, so defendant also prepare their documents. Right? Prepare the same list with the same marking. The column for marking. And then the defendant solicitor will need to send first the marking copy of the plaintiff document. Secondly, the defendant's document with the marking column. Right? So defendant send to plaintiff. Plaintiff will mark the documents sent by the defendant. A, B, C. After the plaintiff has marked the document, right? The plaintiff need to compile the document in one bundle according to the marking by both solicitors on both lists, list plaintiff and list defendant, defendant's list and plaintiff list, in one bundle of document. Okay? Normally, in the situation when we have a physical class or physical hearing, you will need to file the hard copy, right? You will need to prepare the bundle. You will need to bind the bundles, use comb binding or whatever. Normally, we use comb binding. So now we have online classes, so you cannot send to me all the hard copies, and definitely you cannot go to bookshop or stationery or photostat shop to prepare the bundles. So you just you have this PDF reader software applications or whatnot. So you combine your documents into one PDF document. Okay? Now remember, you have your bundles, part A, part B, part C. You combine everything in one single PDF document. Right? So that is your bundle in soft copy. Okay. So then you might ask, sir, where do we get the documents? You need to prepare your documents. Okay, you remember when you file, I believe that when you file your application for injunction, your notice of application for injunction, you need to file your affidavit in support, right? So in that affidavit in support, you need to attach the exhibit to your affidavits, right? So the exhibit to your affidavit is the documents that you need to create, isn't it? You created the document, okay, using your expertise in Photoshop. Students sekarang semua pandai Photoshop, right? Okay, so ada yang buat business Photoshop, dia buka business buat documents untuk civil procedure. Ada tak? Satu documents RM15. Dekat saya mengajar UIA, ada orang buat business. Create exhibits. Okay, so siapa yang pandai Photoshop, now you have idea. This is a very good business model. Okay, ada 90 student nak buat exhibits tapi tak semua pandai Photoshop, right? So, okay, you buat business. Okay, so you create those documents. Okay, those documents will be your documents in the bundle of documents, right? And then defendant will also have to file affidavit in reply. Affidavit in reply also consisting of the exhibits that defendant, want to prove. So that documents will become the defendant's document to be filed in the common bundles of documents. So you just recycle the documents lah, basically. So tak payahlah you nak create dokumen baru. Okay, because you dah buat dalam civil procedure punya document. Use the same documents, just prepare the list, propose to defendant like I said, and then defendant propose to plaintiff, and then you just compile. Right? I don't think it's a difficult task. You have in one PDF documents, combine everything, and then you file your bundles of document into the classroom. Right? So the due date for this assignment, of course, is after the semester break. On the next Thursday lah, before our class. I will give the instruction, the complete instruction in the Google Classroom. Okay? So I hope with that bundles of documents that you file, we can conduct the simulation after the semester break in preparing the witness statement, examination of witness and things like that. Okay? You know this is the first time this subject is introduced in USIM. So I am the first lecturer of this subject. So I really need to try and error to give you the best structure to learn civil trial advocacy. So bear with me. Okay, bear with me. I'm still finding the tune here. And at the same time, I don't want to burden you guys with, I can ask you to prepare pleadings. I can ask you to prepare statement of claim, defense, reply, semua tu balik. But I think, you all akan pengsan nanti. Because you have so many assignments that you need to do. And you are at the convenience of your home. Kan? Nak masak ni lagi, nak tumbuk sambal belacan ni lagi, nak main PUBG ni lagi, nak main, macam-macam dekat rumah. So I know it's difficult, right? You might not have that time. And then you banyak kelas-kelas yang lain lagi that you need to prepare your assignments. But still, what to do? You need to prepare the documents. Okay. Now tonight, that is the assignment. Finish on that. I will give instruction. Tonight I want to talk about first about the conduct of the trial during examination of witness. We have talked about the method, okay, the 10th commandment of cross-examination. And also, re-examination EIC. You remember the 3 sessions? The first session is EIC by way of witness statement. And then you have the cross-examination, the 10th commandment of cross-examination. You remember those baby steps. You remember the don't ask one question too many, all those things that you need to master. And then you have your re-examination, whereby the solicitor who called the witness has opportunity to ask question. And you, by now, you already know in EIC and re-examination, you cannot ask leading questions. right? You can only ask leading question or whatever type of question during your cross-examination sessions. Tonight, I will try to discuss on the conduct of the additional feature of conducting trial. And then if time permits, we talk about the submission, how to prepare written submissions and how to argue, how to prepare or how to, make a oral submissions in court. Okay, first, during your examination in chief, you will have to tender your exhibit. Okay, exhibit ni, kalau dalam affidavit, you just masuk kat belakang, attach to the affidavit. But when you go to court for a trial, you remember you have filed your bundles of document A, B, C. You go to trial. You bawa the bundles of document. You bawa the statement of agreed facts. You bawa issues to be tried. Semua dokumen yang kita dah file. You go to trial. You bring along your witness. Your witness will bring along his witness statement, and then the witness will be called to enter the witness box. Masuk witness box. Okay, first bila masuk witness box, you buat apa? The interpreter will ask the witness to angkat sumpah, to take the oath. Okay, saya bla 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 bla, seorang berikrar bahawa keterangan yang saya akan berikan adalah keterangan yang benar, tidak ada yang tidak benar, melainkan benar-benar belaka. Okay, take an oath. And then after take an oath, you will inform the court. You will inform the court. Lawyer akan bangun, lawyer akan cakap apa? Yang Arif, untuk saksi ini, saya telah menyediakan penyata saksi, witness statement. Saya telah menyediakan penyata saksi. Okay, you dah file penyata saksi, dah file. Okay, izinkan saya untuk bertanya soalan kepada saksi. So, you pun tanya soalan kepada saksi. Encik, adakah ada bersama Encik penyata saksi Encik? Ya. Adakah jawapan-jawapan, boleh Cik sahkan bahawa jawapan-jawapan dalam penyata saksi itu adalah jawapan-jawapan yang benar? Betul, ini jawapan yang benar. Okay. Then the lawyer will ask the judge, will take instruction from the judge, Yang Arif, boleh saya mohon untuk saksi tanda tangan witness statement. You remember your witness statement, when you file your witness statement belum tanda tangan lagi. I explain this to you. So you ask the permission from judge for the witness to sign. So witness pun sign 3 kopi, sign habis, right? Okay. Bila dah habis, dah sign witness statement, you can ask additional question. Remember, kalau you ada additional question, you boleh ask. Tapi let's say there's no additional question. Judge akan tanya, do you have additional question? Ada soalan tambahan, counsel? Oh, saya tidak ada soalan tambahan. Okay. What next to be done before you offer your witness for cross-examination by the defendant solicitor adalah you need to tender the exhibit. This is important. You need to tender your exhibit. Okay, your witness statement. Dalam witness statement, nanti perhaps maybe I can share in classroom the sample of witness statement. Okay, banyak sampel saya ada. So in the witness statement, for example, you tanya soalan, witness statement will refer to the bundles of document. Remember, we have the common bundle. We have the witness statement. Contoh soalan dalam witness statement, contoh soalan nombor 3, Tuan, boleh Tuan rujuk muka surat 2 ikatan dokumen bersama, which is the bundles. Okay, right? Ikatan dokumen bersama. This is the question in the witness statement, ya. So, refer to page 2. Dalam witness statement tu dia cakap pula, boleh Tuan jelaskan apakah dokumen tersebut? The question. Right? So, the answer in the witness statement, dokumen tersebut adalah merupakan satu surat perjanjian antara plaintiff dan defendant berkenaan dengan penjualan sebuah rumah yang bernombor 2 Jalan Angkasa. Whatever. Alright? So that is the answer. So kemudian soalan nombor 4, 5, 6 dan seterusnya sampailah habis cerita. I just give you an example of question. You have the question. Okay, now you have the question in your witness statement which refers to the document. Maybe some of the question doesn't refer to any document, but this question refers to the document. Okay, when the question in the witness statement refers to a document, you need to tender the document. You need to mark the document. Walaupun dokumen, bundles of document tu you dah file dalam court, right? You dah file dah. But you need to tender properly to be admitted as evidence in court. And then all your evidence law come into place lah. Right? You dah belajar evidence, right? Dah ambil evidence lah? Okay. All the evidence come into play. Okay, your primary evidence, your secondary evidence, your section 73, your the document what do you call that, the computer generated documents under section 90A, all that come into play. Okay, so how to tender exhibit? You dah habis sign witness statement tadi. Witness statement has already been signed. You minta the permission from court. Ya Arif, saya pohon untuk menandakan exhibit. Okay, saya pohon untuk menandakan exhibit. This is when after the witness sign the witness statement, right? Okay, habis. Pohon untuk tandakan exhibit. The lawyer, you will go through the witness statement straight to the question which refers to document. For example tadi soalan nombor 1 tak refer. Sebab soalan nombor 1 tanya awak kerja apa. Soalan nombor 2 tanya apa peranan awak dalam syarikat. Nombor 3 semua tak ada. Soalan nombor 5. Soalan nombor 5 ada refer kepada muka surat 2 tadi, which is surat perjanjian. Right? So, terus cakap ni Arif, dokumen pertama adalah pada muka surat, pada soalan nombor 5. Okay? Dokumen pertama untuk ditandakan adalah adalah pada soalan nombor 5, muka surat 3, muka surat 2 whatever, muka surat 2, bundles of document. Common bundle tadi lah. Okay, soalan 5 merujuk kepada dokumen di muka surat 2, ikatan dokumen bersama. Okay, saya pohon tandakan dokumen ini sebagai exhibit. Right? Kena cakap, kena minta permission from court. Saya mohon tandakan dokumen ini sebagai exhibit. Okay, so court pun akan cakap, okay, ini dokumen yang dipersetujui kan. Dia mungkin akan tanyalah, ini dokumen part apa? Part A. Part A maksudnya there is no dispute. Part A, there is no dispute, remember? There is no dispute as to the content and as to the authenticity of document. Keesahan dan juga kandungan tidak dipertikai. Jadi court pun cakap, okay, dokumen in part A tidak dipertikai, maka dokumen ini ditandakan sebagai P1. Okay, sebab plaintiff yang tender dokumen. Plaintiff start the case kan. So plaintiff tanda the dokumen. Dokumen ini ditandakan sebagai P1. So kita pun ada, we have our bundles, right? We have our bundles, we have our index. Kita buka index, kita tulis dekat tepi tu P1 dekat tepi dokumen pertama. That is question number 5, right? So, the next question yang refer to document may be question number 12. Okay, seterusnya ya Arif, saya rujuk kepada soalan nombor 12. Soalan nombor 12 merujuk kepada dokumen di muka surat 83 of the bundles. Right? So, tengok. Judge pun tanya, okay? Oh, dokumen ni part apa? A ke B ke C? Dokumen ni part C. Okay? So, maybe part C. Part C maksudnya apa? The defendant doesn't agree to authenticity and content. Tak agree langsung. Tak agree langsung. Awak memang tak agree langsung. Okay? Tapi you nak tender the document which is not agreeable by the defendant. Macam mana? So dia cakap, ya Arif, soalan 12 tadi merujuk pada dokumen di muka surat 83 dan ini adalah dokumen Part C. Hakim akan tanya apa? Okey defendant, dokumen ni Part C, ada apa bantahan ataupun apa asas bantahan awak? Kan? C is disputed, right? So hakim akan tanya, apa asas bantahan awak? Okay, kita mah, ya Arif, saya membantah kerana dokumen ini tidak ada original. Then all your evidence come into play lah. Kan? Oh, ini adalah secondary evidence yang tidak dapat dibuktikan sebab tidak ada tidak dipanggil pembuat dokumen. The maker of the document was not called. Right? All the evidence. Okay, your evidence law, Augustine Paul tu, buku Augustine Paul tu, comes into play masa ni lah. Masa the process of tendering exhibit. Itulah tujuannya you all belajar evidence. Faham? Bila kita buat civil trial advocacy ni, you kena apply semua benda 4 tahun, 5 tahun belajar ni di dalam di subject. Company law, apa semua, contract law, all those evidence act, semua masuk semua sekali dalam ni, civil procedure semua. Okay? So now you see. Argue lah. Defendant akan argue, oh maker tak panggil. Defendant akan argue, original tak ada. Defendant akan argue bla bla bla. Mahkamah eventually need to make a decision. Right? Okay. Okay, dah argue. Okay, saya berpendapat tidak perlu panggil maker sebab dokumen ni adalah dokumen kerajaan yang saya rasa jelas, tidak perlu dipertikaikan, maka mahkamah menerima dokumen ini sebagai exhibit. Okay, terima maksudnya admitted as evidence. Okay, you tengok balik admissibility of evidence. Evidence law lah ni. Admissibility of evidence. Kalau saya ulang 10 semester tak habis. Semua subjek I need to repeat. Alright? So, you tengok balik admissibility of evidence. Okay, mahkamah cakap, saya setuju, saya terima dokumen ini sebagai exhibit dan ditandakan sebagai apa?
P1.
Teka lah sikit. Tandakan sebagai
P2.
Yeah, P2. Tadi P1 kan? Now, it follows the next document would be P2. Okay, dan ditandakan sebagai P2. Right, habis lah. Okay, kemudian next document. Dokumen seterusnya yang Arif adalah pada soalan nombor 80. Tebal witness statement kan? Soalan nombor 80. Nombor 80 merujuk kepada dokumen di muka surat 30 dalam bundles of document. So you pun, ya Arif macam biasa ya Arif tanya. So di dokumen part apa? Part B. Part B. Okay, Part B saya terima sebagai Part B, tak perlulah konten saja yang dipertikai, tetapi authenticity tidak was not question, right? So okay, saya terima dan dokumen ini ditandakan sebagai P3. So that is the process of tendering exhibit. Itu caranya. So sampailah habis semua documents yang referred to in the witness statement has been tendered. So kalau you prepare witness statement, kalau saya punya style, bila you pergi court, you ambil highlight kuning, you highlight lah siap-siap the question that refers to document. So nanti bila you go through, you tak terlepas the documents. Nanti dah lah habis, alamak ada satu terlepas, you know. Biasalah kan, but you highlight the question which refers to documents. Dalam 100 soalan, maybe ada 20 question which refers to document. But not all. Okay, so that is how you tender the exhibits. Right, okay. And then, any question on that before I move to... Okay, same goes to the defendant. Bila defendant, okay, plaintiff dah panggil saksi pertama, saksi kedua. Saksi kedua pula sama juga proses. Ulang, tender the witness statement and then tender the exhibit. The numbering, the sequence of numbering will continue First witness mungkin habis sampai P20. Right? So panggil second witness, tanya semua tadi, tender witness statement. The first exhibit for second witness akan start P21, P22 sampailah P40. And then third witness start P41, and it follows. Habis, plaintiff close case. Plaintiff dah panggil 3 witness. Dah cross, dah semua. Saya tak cerita. I cut short the story. You already understand this. I hope you understand lah. Nanti saya tanya pula, sir, saya cakap 3 witness ni crossnya masa bila? After you tender exhibit, you will offer the witness to the defendant. Okay, saya itu saja yang Arif. Saya serahkan saksi ini kepada defendant untuk soal balas, pemeriksaan balas. So dia pun tanyalah, yang saya duk ajar cross-examination tu comes into play lah. And then habis, re-exam balik. All witness sama, same process. Dah habis 3 plaintiff, saksi plaintiff pun, mahkamah pun akan tanya, ya plaintiff ada saksi lain? You will answer that plaintiff tidak ada saksi lain lagi. Plaintiff dengar, this is important words, this is important ayat. Plaintiff dengan ini menutup kes plaintiff. Right? Habis 3 witness, tak ada witness lah. Plaintiff dengan ini, Arif, menutup kes plaintiff. Habis. Khalas. Betul lah, khalas. Right? Habis. And then next is what? Next is defendant. Okay, defendant boleh start case. Defendant pun bangun. Lawyer defendant bangun. Lawyer defendant je kata, ya Arif, saya ada 2 orang saksi sahaja. Saya dengan ini memanggil saksi pertama defendant. Siapa. Doktor ke apa. Okay, so saksi defendant pun masuk kandang saksi, go through the same process all over again. Tanya dia ada witness statement ke tak, jawapan dia adalah benar ke tak, minta dia sign, and then the defendant will start the process of tendering exhibit. Sama macam tadi kan? So defendant pun cakap, okay, refer soalan 13, dokumen ni, bla bla bla. And then the court, okay, mahkamah terima, the document, ada the document, dan mahkamah tandakan sebagai D1, right? Sebagai D1 because it is a defendant's witness. So start balik sequence daripada awal, tadi dah P80, start balik D1. Sampailah 2 orang witness habis D18 ke D20 ke apa, tak kisahlah. It follows and continue the same process. Okay, so that is tendering of exhibit. Okay, ada soalan pasal tender exhibit?
Saya nak tanya, sir.
Yes.
Saya Muhammad Imran. Saya nak tanya, waktu selepas re-examination of witnesses and juga exhibit tu juga ke court akan reject exhibit kita tu? Ataupun kita tunggu dah hujung trial, barulah court decide exhibit ni admissible ataupun rejected.
Okay, good question Imran, thank you. Okay, with regards to tendering, the court will decide there and there. The court akan decide masa tu juga whether the court admit or not. Bila court cakap tadi, mahkamah terima sebagai exhibit, mahkamah tanda sebagai P1. Okay? Tetapi, you dah habis kes, defendant dah tutup kes, you are not stopped. Kamu adalah tidak dihalang daripada nak argue lagi on the admissibility. You can still argue on the admissibility. Walaupun mahkamah dah mark P1, tak apa, you boleh argue lagi. Kalau you nak argue. But normally tak ada argument dah lah. Tapi court you nak argue lagi on the admissibility, you can still argue in your final submission about the admissibility. Okay. Dekat sini, saya refresh your memory on the evidence. It is very important. It is very important note. Evidence ada 2. Evidence ada banyak. Evidence ada dua prinsip that you must really understand. Dua prinsip. Satu is admissibility. Okay, macam Imran tanya tadi. That is admissibility. Kebolehterimaan dokumen. Kebolehterimaan ni you argue apa? You argue tadilah. Secondary evidence, primary evidence, maker panggil, maker tak panggil, original ada, original tak ada, dokumen ni forged ke apa semua, itu adalah kebolehterimaan. You keluar balik all evidence law, right? Nombor satu. Number dua, with regards to evidence, is the weight, pemberat, weightage, ataupun pemberat, ataupun value, nilai. You can call it what, tapi normally kita call it weight. Weight berat lah kan, weightage, weight, whatever. Okay, but use the weight kepada dokumen tersebut. Okay, kena clear yang ni. Kalaupun satu dokumen, ni telefon, kalaupun satu dokumen is admissible, telah diterima sebagai exhibit, tetapi adakah evidence ni ada nilainya to your case? Right? Betul, diterima. Tapi terima masuk as to the admissibility saja. Mahkamah terima ia masuk sebagai evidence. Tetapi di hujung nanti you can argue dokumen ni tak ada nilai apa pun. There's no weight as to this document. Sebab dokumen ni tidak membuktikan apa? Your cause of action. This document doesn't prove your facts. This document doesn't prove your the elements of cause of action, for example. You bagi dokumen yang tak ada nilai. Okay? So, kita lawyer, we want to give the document yang have all this too. Dokumen yang admissible, number one. Dokumen yang ada weight to your case. Right? Barulah dia jadi evidence yang elok. Bukan bagi dokumen masuk admissible, ujung-ujung semua tak boleh pakai. Bukan tak boleh pakai, boleh pakai, tapi tak ada nilai. Doesn't have any value to your case. You got what I mean or not? This is very important. This is very important. So, bagi dokumen yang ada nilai. Macam mana nak tahu dokumen ada nilai ke tak? You remember our first lesson? The 5-level case analysis. Remember? Angguk pun slow. Ada, ingat tapi first lesson, first class, 5-level case analysis. Flip, note tak boleh. Lagi. 5-level case analysis. Pertama, kita ada source of law. Kedua, kita ada cause of action. Kemudian, kita ada element of the cause of action. And then, kita ada facts to prove that element. And then, the last apa? Last level apa?
Evidence required.
Evidence to support the facts. Yes. Evidence ni lah yang kita cakap admissible and ada weight to your case. So the evidence you tendered mesti support the facts, yang support the element, yang support the cause of action, yang support the source of law. Kalau evidence bagi doesn't support any facts, tak ada weight lah. Admissible but no weight. Tak guna. Right? Okay. Number one. Number two, mungkin ada orang tanya, Sir cakap tadi kalau court terima, kalau court tak terima apa jadi? Right? When the court accepted the evidence, the court will mark it as P1, P18, P132, D40, D46. But what if the court decide? For example, the documents in bundle C. Okay? The document in bundle C, Ya Arif, saya refer kepada soalan nombor 12 yang merujuk kepada dokumen di muka surat 100. Court tanya, ni dokumen part apa? Part C. Okay, part C. Defendant, apa yang tak setujunya dokumen ni? oh yang Arif, saya tak setuju dokumen ni sebab dokumen ni adalah dikeluarkan oleh sebuah syarikat bernama ABC. Okey, syarikat ni yang membekal simen kepada defendant, whatever. Okey, tetapi pekerja syarikat itu tidak dipanggil untuk memberi keterangan. Dokumen tu pula photostat. Right? Dan dokumen photostat tadi ni ditender melalui witness, iaitu defendant yang merupakan orang yang menerima dokumen tersebut. Okay, orang yang terima. Okay, saya ulang sekali. You need to imagine this. Dia adalah satu surat daripada company A kepada defendant. A tulis surat kepada defendant. Defendant terima surat. Right? Defendant terima surat. Yang dipanggil sebagai saksi adalah defendant. Defendant pun cakap soalan dia apa? Boleh terangkan dokumen tersebut? Dokumen tersebut adalah surat yang dikeluarkan oleh syarikat ABC yang diterima oleh saya pada 1 hari bulan Januari 2020. Okay? Who issued that document? Company ABC. Company ABC is not the party to the suit. Right? Siapa receive the document? The defendant. Okay, who's the maker of that document? Company ABC. Yes. The maker of the document. Original ada kat mana? Mungkin ada dengan company ABC. Yang defendant bawa ni hanyalah photostat. So who should testify as to the admission of the document? Somebody from ABC. So defendant object. Plaintiff object, saya terbalik lah. Okay, plaintiff object. Ni defendant punya witness. Plaintiff object. Plaintiff kata, ya Arif, ini dokumen dalam part C kerana ia ditanda melalui orang yang bukan pembuatnya. Ia ingin ditandakan melalui orang yang bukan makernya. Jadi kami terpaksa objek. Sebab kita tak tahu surat tu dikeluarkan betul ataupun tidak. Yang tahunya adalah syarikat ABC, which was not called as witness. Dah lah bawa photostat copy. Kalau bawa original dokumen, tahan lagi. Bolehlah kami agree. Kami tak agree. Mahkamah pun fikir. Saya rasa saya setuju lah dengan plaintiff. Macam mana kita nak tahu dokumen ni betul ni? Okey, saya dengan ini menolak dokumen ini dan menandakan sebagai teka.
D2.
Sebagai apa? Ha? Tanda sebagai apa?
Negatif 1.
Kreatif tu idea tu. Idea tu kreatif. Ditandakan sebagai ini dah belajar tapi tak ingat. Belajar dalam evidence. Ditandakan sebagai ID. Kalau last sequence adalah P15. Okay, last document adalah P15. Dokumen seterusnya duk argue, court tak terima. Court cakap macam saya cakap tadi, court tak terima, court tandakan sebagai ID tadi P15, ID 16. P15, ID 16. The numbering sequence continue. Tetapi dia tidak P sebab dia tidak diterima. Dia dinamakan sebagai ID. Sir, apa benda ID ni? P tu kita faham lah plaintiff. D tu defendant. ID ni apa? ID is identified document. Dokumen yang dikenal pasti sahaja. Dikenal pasti tapi tidak diterima. Faham tak? Dikenal pasti. Identified document. Right? So, identified document. Identified document means ia tidak diterima sebagai exhibit, tetapi orang yang pihak yang mengemukakan dokumen tersebut ada peluang untuk memperbaiki dia dan tukar kepada exhibit P. Dengan cara apa? How do you make the ID P? nak tukar ID kepada P dengan cara apa?
Argue balik.
No. Dengan cara apa?
Tender balik.
Evidence lagi.
Yes. Good. Memanggil pembuat dokumen lah. You call the maker. Tadi isu tadi apa? Isu tadi maker tidak dipanggil. Tender through defendant, right? So mahkamah tak terima. Mahkamah cakap ID. Macam mana you nak tukar ID tadi kepada P or D or whatever? You call the maker. Okay, tak apa ya Arif, kami akan cuba cari pemilik syarikat ABC ataupun pekerja ataupun pengarah syarikat ABC yang menandatangani surat tersebut. Panggil lah. Right? Panggil lah. Bila panggil, pengarah tu pun datang. Okay, saya tak nak cerita lagi dia Sapina ke dia apa. Tapi let's say assume dia datang, kita pun tanya dia. Okay, Tuan. Tuan ni dia pengarah ABC ya, betul? Tuan rujuk kepada muka surat 100 tadi dalam bundle. Okey, ini ada dokumen ya, surat daripada syarikat tuan kepada defendant. Okey, tuan boleh sahkan adakah tuan yang tanda tangani surat ni? Ya betul, saya tanda tangani. Ini tanda tangan saya. Jadi betul surat ni dikeluarkan pada sekian tarikh, betul? Dan surat ini ditujukan kepada defendant dan diserah hantar secara betul? Ya betul. Peguam bangun, peguam cakap apa? Tuan ya Arif, dokumen ini telah ditandakan terlebih dahulu sebagai ID 16. Saya mohon untuk diterima sebagai P6 dan ditukar kepada P16. Tukarlah P16 sebab apa? Habis dah objection daripada defendant tadi, tak ada nak objek dah lah. Maker dah datang. Original pula bawa. You know? That is how you convert. Kalau sampai ke hujung trial, you tak boleh nak cari witness, you tak boleh nak cari original, you tak dapat nak repair the ID document. ID document will remain as ID document and you cannot use it in your argument. Tak boleh guna. Sebab it is not admissible. Right? So, dalam final submission tu tak adalah pula lawyer refer saya merujuk kepada ID 16, tak adalah. Kami merujuk kepada P6, P7, D8, D10 tu je. Because it is not admissible. Okay. So, akan bila mahkamah buat keputusan baru kita nak cari witness? Kan? Baru nak cari tehegi cari witness? Tidak. You dah tahu dia C dan defendant object masa bila? Masa bila you tahu defendant will object to that document or plaintiff will object to that document? Masa bila you tahu?
Masa kita exchange pleading.
Yes. Kan? Masa bukan pleading. When we exchange the draft yang kita cakap tadi. Masa kita exchange the proposed index untuk defendant mark. Bila dah dokumen tu defendant mark C, tentu-tentulah dia akan object apa nama the maker or the original. Ini berlaku bila? This is way before trial. Ini sebelum trial, 2-3 bulan sebelum bicara. Jadi you dah tahu defendant akan petikaikan that document. You buat apa? Carilah witness. Carilah original. Inilah kerja lawyer. Kalau company syarikat ABC tak bagi kerjasama, Sapina lah. Ataupun you pergi jumpa dia tanya, kita nak kena panggil tuan ni sebab dia orang objek dokumen ni. Jadi tuan nak kena testify as a witness just to confirm you tulis surat ni. Tu je. Right? So, you pergi to trial with well prepared. Dokumen C semua, sama ada you dah original ataupun you dah bawa saksi tu testify on that document, which is the maker of that document. Jadi tak timbul lah macam situasi saya cakap tadi. Situasi saya cakap tu hypothetical saja. Tiba-tiba jadi ID, kita akan cari. Tak lah. You dah kena cari daripada awal lah. Right? The saksi. Lepas tu, bila mark SID tadi, bila you dah ada saksi, you janganlah tender the dokumen melalui orang yang bukan maker dan dapat ID. You simpanlah dokumen tu, you tenderlah nanti through the maker yang you dah prepare untuk panggil, right? Teruslah jadi P. So that is the proper way of tendering evidence, right? So semua make sure dokumen tu, make sure semua dapat P. Kalau defender semua dapat D. Jangan sekali-kali you tinggal dokumen habis trial tengok-tengok, alamak, apa salah ada ID lagi ni? Apa salah ada ID lagi? Maksudnya, your tendering of exhibit, your evidence ada masalah. You ada problem in tendering your evidence. We are not talking about weight lagi. We don't even talk about value and weight lagi. We only talk about admissibility. Right? Admissibility, you ada problem. Bila dokumen tak ada, this is civil trial. This is not criminal trial. Civil trial is about documents. Kalau tak ada dokumen, susah lah you nak submit. You tak boleh submit pun kalau bagi ID. You tak boleh nak berhujah dengan ID dokumen. Any other question? Pasal ni. Yang ni kena clear betul-betul. Okay faham Okay, that is apa yang saya nak cakap pasal tendering evidence. Tendering evidence dan exhibit tadi. Itu kira the whole process tu. The whole process. Okay. The last half an hour ni, saya nak cerita pasal bantahan. Kita tengok dalam movie. Oh, sikit-sikit objection, Your Honor. Bantahannya Arif. Nak bantah apa sebenarnya? Nak bantah apa? Kan? Right? Apa benda? What is the objection you want to make? Nah, ini kita nak belajar. What is the objection that you want to make? Apakah bantahan yang you nak buat ni? Duk bangun tiba-tiba buat garang ni. No, bantahan ni Arif. Dia nak bantah apa? Saya pun tak tahu. You must have the reason. You must have a ground to object. The first ground to object is the question refers to a fact which was not pleaded. Okay? Soalan tersebut merujuk kepada fakta yang tidak dipleadkan. Okay? You remember your civil procedure? I suppose that your lecturer already explained this. Okay? Parties are bound by pleading. Pihak-pihak adalah terikat dengan pleading. Pleading ni apa? Statement of claim. Pleading ni apa? Your statement of defense. Pleading ni apa? Jawapan kepada pembelaan or reply to defense. That is pleading. Apa saja kenyataan di dalam statement of claim, di dalam statement of defense, di dalam reply, that is a pleaded facts. We call it pleaded facts. Fakta-fakta yang dipleadkan. Okay? For example, you cerita pasal apa? Case bagi contoh payah sikit. Case defamation, alright? Defamation. Okay, case defamation you pun cerita dia a defender publish post Facebook yang katakan bahawa plaintiff pencuri 2.6 bilion. Pencuri 2.6 sen. Okay? Pencuri. Lepas tu tidak berkait. Lepas tu cerita lagi. Posting Facebook tu orang like berapa banyak. Okay, disebab posting Facebook tersebut plaintiff mengalami kecederaan. Reputasi plaintiff terjejas sebagai seorang ahli politik. Okay? Ahli politik sebagai seorang ketua kampung. Reputasi plaintiff terjejas bla 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 bla, tuntut damages RM5,000. Okay, you plead. Defend pula cakap, tak, saya tak. Satu, bila saya tulis artikel tu, saya tak bermaksud kepada plaintiff. Saya sebut nama dia, saya sebut secara umum saja. Okay, Razif. Tapi tak bermaksud Razif ketua kampung ni. Kan, mungkin Razif siapa, orang lain. Dia perasan dia. Defend. And then, saya pula cakap pencuri, tapi saya tak cakap saya pencuri RM2.60. Tapi apa, tak jelas lah yang saya nak kata kat dia. Whatever lah, saya just reka je. Okay, that is pleaded. Tiba-tiba bila panggil plaintiff panggil witness, lawyer plaintiff panggil plaintiff sendiri testify, lawyer plaintiff tanya, saya nak rujuk kepada satu posting Facebook yang dibuat 2 tahun lepas, sebelum posting Facebook ni, yang dibuat oleh defendant juga, yang cerita benda lain, yang cerita pasal curi RM1.30. Contoh, saya bagi contoh. Tadi ni Facebook posting yang baru ni curi RM2.60, tapi dia nak tanya soalan pasal statement Facebook 2 tahun lepas curi RM1.30. Number one, whether it's pleaded. Dia tak cerita dalam statement of claim. It is not pleaded. Okay, kalau you nak kena cerita as a background, you kena plead. You tak cerita. So lawyer pun tanya, it could be dalam EIC lah, dalam witness statement. Tapi saya assume lawyer tanyalah, senang supaya pemahaman. Boleh ceritakan kepada saya tentang satu posting yang berlaku pada 2018 di Facebook defendant. Dia berkenaan dengan satu kecurian RM1.30. Okey, defendant masa ni kena buat pergegaran. Defendant bangun, bantahan ni Arif. Masa ni lah. Bantahan ni Arif. Ya, nak bantah apa? Ya Arif, soalan ini merujuk kepada satu fakta yang tidak pernah dipleadkan oleh plaintiff. Nampak? Satu fakta yang tidak pernah dipleadkan oleh plaintiff. Plaintiff hanya mempleadkan kecurian RM2.60 oleh ketua kampung Razif. Tetapi plaintiff tidak merujuk kepada Facebook posting yang dibuat 2 tahun lepas tentang kecurian RM1.30. Okey, Arif pun, ya ke? Plaintiff, betul ke tak plead? Buka tengok statement of claim sekarang. Semua pakai buka statement of claim. Cari. Kat mana you plead pasal RM1.30 ni? Posting Facebook pada tahun 2018. Buat silap, buat macam ada kan. Ya Arif, sebenarnya memang tak ada ya Arif. Kita tak sebut secara spesifik. Habis tak sebut lah. Secara spesifik tak sebut ya Arif, tapi kita sebut secara general. Kat mana secara general? Ni defendant telah mempostkan posting Facebook tentang RM2.60 dan atau posting-posting yang lain. Itu tak boleh lah. You tak spesifik tentang 2 tahun lepas. Tak ada kan? Tak ada ya Arif. Okey, bantahan diterima. Soalan tersebut tidak boleh ditanya. Nampak? That is bantahan. Fakta yang soalan tersebut bertanya fakta yang tidak dipleadkan oleh pihak-pihak. Bantahan. Okey? Ada banyak ni. Baru satu ni. 945 dah. Aduh. Okey? Nombor 2. Bantahan nombor 2 adalah apabila fakta tersebut, soalan tersebut adalah soalan yang tak relevan langsung kepada kes. Irrelevant. Okey? Relevancy of question, relevancy of facts ni, you nak tengok kat mana? Your Evidence Act lah. Your Evidence belajar dulu. You belajar Augustine Paul. Judge yang paling banyak rule out irrelevant. Semua irrelevant. Right? You tengok kes Anwar Ibrahim. Awal-awal Augustine Paul punya decision kan, for whatever it was. Tapi irrelevant. So, this is the objection. Cerita kes ni pasal kes defamation. Tiba-tiba defendant bangun. Cross. For plaintiff witness. Plaintiff setuju dengan saya bahawa anda mempunyai 3 orang isteri. Apa kaitan pula? So, plaintiff lawyer bangun. Bantahan ni Arif. Nak bantah apa? Apa kaitannya dia ada 3 orang bini ke 8 orang anak ke dengan saman defendant for defamation. Dia tanya pasal bini dia berapa orang tu. Tak, ini relevan ni Arif untuk menunjukkan bahawa latar belakang plaintiff. Apa kena mengena latar belakang plaintiff dengan tuntutan defamation ini? Irrelevant. Right? Okay. Saya terima bantahan. Soalan tersebut tidak boleh ditanyakan sebab irrelevant. Right? Bangun pula tanya. Setuju dengan saya bahawa makanan kegemaran anda ialah nasi goreng. Apa relevannya? So, if you keep asking irrelevant question, then defender will bangun untuk bantah. Apa kaitannya, Arif? Dia bantah. Masa tu kena bantah kuat sikit. Bantahan ni, Arif. Apa kaitan makanan kegemaran dia, hobi dia, apa ni semua dengan all this case? I mean, I give extreme example lah. But it might not be that extreme. Lawyer tu sama ada dia ada kecacatan kekal dekat otak dia kalau dia tanya soalan macam tu. Otherwise, dia akan tanya macam nampak macam relevan tapi sebenarnya tak relevan. So you object. Relevancy of the question. Thirdly, nombor 3. Hypothetical question. Question yang bercorak hypothetical. Yang bercorak memberikan hipotesis.
Kesimpulan.
Maksudnya apa? Apa benda hypothetical? What is hypothetical? Something yang tidak berlaku tetapi digambarkan berlaku, dan kalau ianya berlaku, adakah begini? Hypothetical, nampak? Okay? Betul, saya tahu dalam kes ni tak berlaku. Tapi kalau berlaku, apakah reaksi tuan? Contoh. Kan? Okey. Ini susah sikit nak bagi contoh. Dalam kes defamation tadi, contohnya apa nak bagi contoh? Tapi hypothetical macam tu lah. Maksudnya contoh sebagai, kita ambil kes lain. Kita ambil kes contohnya, kita nak cakap pengarah syarikat ni pecah amanah. Pecah amanah, syarikat saman pengarah ni yang telah pecah amanah buat lari duit whatever lah. Okay. Tapi fakta yang dipelitkan tu tidak menunjukkan bahawa dia sign dokumen palsu. Contoh saya bagi contoh. Hypothetical question. Setuju tak dengan saya? Kalau awak sebagai pengarah ni membuat dokumen palsu, sudah pasti pengarah-pengarah lain akan tahu tentang benda ni. Okey, dibantah ni Arif. Kenapa nak bantah? Hypothetical. Benda tak berlaku pun. Sebab bertanya soalan, memberi satu andaian benda yang tidak berlaku. Kita bukan tanya pasal andaian. Kita tanya pasal fakta. Kita tak boleh tanya, kalau benda ni berlaku, apakah reaksi anda? Kalau ini berlaku, adakah ini akan berlaku? Okey. Ini kita kata apa? Kalau guna kalau ni setan kan. Saya tak tahulah whether it's correct context or not. Padahal kalau macam tu, kalau dalam konteks yang saya nak cerita ni ialah apabila it is hypothetical situation. Situasi yang tidak berlaku tapi nak ditanya, digambar supaya berlaku. Okey? Digambar supaya berlaku. Okey, Tuan seorang lelaki kan? Lelaki. Andaikan kalau Tuan ni seorang perempuan. Andaikan kalau Tuan ni seorang perempuan, Tuan akan beli tak ni produk yang diciplak ni? Kita cerita pasal thought of infringement for example. Kan? Dia produk bedak muka perempuan. Kita pula tanya saksi lelaki tak? Saya berandaian ni. Andaikan Tuan ni seorang perempuan, asal-asal Tuan berminat tak nak beli produk tu? Bantahan ni Arif. Dia lelaki nak andai apa bendanya? It's a hypothetical. It's a hypothetical situation. Situation which is not happening, tapi you nak minta dia andaikan. The witness cannot answer that kind of question. So, hypothetical question can be objected. Nombor 4, apabila soalan tersebut bertanya pendapat, opinion. Right? Kalau saya ingat, saya dah ajar bahawa saksi, witness adalah witness of fact, not witness of opinion. Unless apa? Witness tu adalah expert.
Opinion.
Kalau you panggil medical expert, dia tak terlibat pun dalam kes ni. You panggil dia for his opinion. Right? You panggil mufti nak testify pasal isu transgender, for example. Right? Oh, ni saman geng Nisha Ayub ni saman Jabatan Agama Islam sebab tangkap transgender, kan, saman civil negligence apa semua. So Jabatan Agama Islam kata, oh, iyalah sebab dia orang ni beramal dengan satu yang bertentangan dengan agama. Nak buktikan bertentangan dengan agama tu kena panggil siapa? Kena panggil mufti. Mufti datang. Apakah pendapat Tuan Mufti tentang kedudukan transgender di dalam Islam? Nah, soalan apa pendapat dah? Oh, dari segi Islam, pendapat saya adalah gini, mazhab gini, apa semua ayat Quran keluar bawah. That is expert opinion. Expert opinion, of course lah. He comes to court to assist the court in giving his opinion. Tetapi, selain daripada expert opinion, you are the witness of fact yang tak boleh tanya pendapat dia. Contoh soalan. Okey, tadi defamation. Okey, defamation. Razif Ketua Kampung saya. Kita pun call Razif. Plaintiff kan? Plaintiff Razif. Kita pun tanya dia setuju atau tidak. Bukan setuju atau tidak. Kita tanya soalan kepada dia. Tuan, Tuan bila Tuan dapat, defendant, tanya defendant. Tuan dapat saman daripada plaintiff. Okay, Tuan dah baca semua pernyataan tuntutan plaintiff. Saya nak tanya Tuan, boleh Tuan bagi pendapat Tuan dari segi, adakah defendant mempunyai kes yang kuat? Adakah plaintiff mempunyai kes yang kuat? Bila Tuan baca statement of claim tu, Tuan rasa adakah defendant mempunyai kes yang kuat? Dia pula tanya defendant, adakah defendant rasa plaintiff mempunyai kes yang kuat? Defendant pun dia, oh memang ni tiada kausa tindakan dalam kes ni. Lawyer dah prep sebelum masuk. Tiada kausa tindakan dalam kes ni. Kan, orang awam sebut, tiada kausa tindakan. Dan saya rasa plaintiff juga tidak ada locus standi untuk memfailkan saman. Dan plaintiff bangun. Bantahan yang Arif. Witness is giving his opinion on law. Not only opinion. Opinion on law pula. Okay? So witness of fact cannot give opinion on whatever lah, on law. Dan apatah lagi kalau dia bagi opinion on law dan dia bagi komen pula tentang kes ni, ada locus ke, ada course of action ke, mahkamah akan straight away jump. Mahkamah akan cakap, it is not for you to decide. Saya yang akan decide. Hakim yang akan decide plaintiff ada locus standi or not, where's the course of action, kes dia kuat ke tak kuat. Yang awak pandai-pandai nak jadi judge ni kenapa? Lawyer, yang awak pun satu hal pergi tanya soalan macam tu, kenapa? Yang awak prep saksi awak untuk jawab soalan macam ni, kenapa? Bantahan. Bantah kerana witness memberikan pendapat. That is number 4. Lastly, badgering witness. Dalam bahasa Melayunya, menghina saksi, mengasari saksi, mengeluarkan kata-kata kesat terhadap saksi. Badgering dia panggil. Ini tak boleh lah. Kita civilized world kan. Tu janganlah macam, setuju tak kalau saya katakan anda seorang yang bodoh? Tak boleh lah. Winner pula setuju tuan. Hari ni hari bodoh saya tuan. That is badgering lah. So, bantah. Ya Arif. Bantahan ya Arif. Peguam mengeluarkan kata-kata kesat dan mengasari saksi. Ini tak boleh dibenarkan. The lawyers is badgering the witness. Tak boleh lah. You know, there's always, saya selalu cakap pada student saya, there's always another words of saying something. You nak cakap A, tapi always ada perkataan lain yang you boleh guna untuk cakap A sampai tujuan A, tapi tidak menggunakan perkataan A. You nak cakap bodoh, you boleh cakap benda lain. Kan? Boleh tak? Setuju ke tak kalau saya katakan bahawa tuan ni ada masalah pemahaman yang serius? Sama tu, bodoh tu. Kan? Tuan ni ada masalah pemahaman yang serius. Ataupun tuan, adakah tuan mempunyai IQ yang rendah daripada biasa? Atau itu tak boleh, itu badgering. Okay, so jangan badger, jangan menghina, jangan what we call mengasari witness. That is not allowed. Dan lawyer sebelah of course boleh jump, tak ada cakap bantahan ya Arif, tak boleh lah macam ni Arif. Kan tanya-tanya aja dah, apa nak hina orang pula, kan? So that is not allowed and you can berbuat bantahan. So we have actually banyak lagi, tapi this is basic thing yang you boleh buat bantahan. Dia kalau dah tahu tanda exhibit, dah tahu dah bantah apa, complete dah drama ni dah complete dah. Pergi kat court dah, wah, dah boleh jadi lawyer untuk conduct the trial. But the reality is harder than theory. Jadi kita cerita teori hari ni memang nampak senang, tapi the reality of practical side of it is you need to practice. Okay, you need to practice. Baru lama-lama you flare, you actually acquire the skill, then you can tender smoothly. You can bantah ni dia kena cepat. Bila you tengok trigger question ni, you nak masuk dalam mana ni? Seajar 5 ni nak masuk dalam mana ni? Kan? Nak masuk dalam mana? Then you need to use. So, it come with experience. So, saya punya niat tadi nak ajar sampai terus.
Nak buat bantahan tu macam dalam filem dia kata kena hentak meja ke, angkat tangan ke, macam mana? Dia just mencelah aku cakap.
Bantahan tu
macam mana praktis dia dalam
caranya mudah saja. Dia jangan tengok sangat filem-filem barat apa semua ni. Kalau tengok cerita law kan, saya tahu dah, aku tengok cerita Korea. Yang Korean apa segala Korean drama ni, tapi yang legal drama dia agak-agak mirip lah sedikit. Kalau macam US ni, satu dah lah lawyer dia boleh berjalan keliling, pergi pusing sana-sana. Kita tak ada, kita duduk statik je. Bantahan ni memang tak meja, tenang kerusi apa semua. So Malaysian court is actually very simple, very mannered, very civilized. Kita ikut UK very civilized, very mannered. Kita nak buat bantahan, kita just bangun bantahan ni Arif, sambil bangun bantahan ni Arif, macam tu je. Ya, bantah apa? Then kita explain our objection, kan? Bantahan. Tapi kena bangun is manner. Jangan bantah sambil dulu. Bantahan ni Arif, tak boleh. That is tak ada manner, tak ada ethics in court. Tak payah tak meja semua, tak payah. Okay? So that's how you object, macam mana cara nak object. But that is perkara yang penting juga. Tapi tak berapa penting. Yang paling penting ialah nak bantah apa. Buat drama pun bagus, nak bantah ni Arif. Bantah apa? Saya bantah lah. Saya memang nak bantah. Yelah, nak bantah apa? Tak, saya tak setuju dengan dia. You have to have the ground of objection. It is hypothetical question, Arif. It is not relevant. It is the witness is giving opinion. Blah 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 blah. Okay guys, saya fikir saya sempat explain to you all the last part of written submission, macam mana nak prepare written submission dan oral. So nampaknya pukul 10 pagi tadi saya ada hearing dekat Federal Court online 2 jam. Saya dah tembik lah, kepala saya pun dah pening lah. Federal Court sekarang hearing online. So online ni dia macam ni lah kan. So you have to argue, kadang-kadang tiba-tiba judge punya suara tak dengar. So kita pula nak kena refer dokumen, kena share screen dengan judge. So very tedious actually. Tapi ada juga bestnya sebab kalau di other side tengah submit tu, you boleh tutup view cam ni dan tutup mikrofon, lepas tu you gelak tengok ni submission dia. Kalau dekat court tak boleh. Tak adalah, I mean you boleh off camera kan, you know. So kadang-kadang macam tiba-tiba lawyer ni off camera, ni mesti nak gelakkan aku ni. So I had a good hearing this morning in federal court. The presiding judge was the CJ herself, Tengku Maimun. So it's issue ni lah, you know, pergi federal court dia question of law apa semua. So dah setengah hari kat situ. So dah tak larat lah. I mean sekarang pun dah pukul 10. Sebab tu saya start lambat. Saya start lambat sebab saya memang lepas maghrib tu saya nak kena rest sekejap, ambil ketenangan. Kalau saya start tu memang saya penat sikit lah. So sorry lah. I just take 1.5 sejam setengah. And then after the break, you buat your assignment. After the break, you submit. And then kita akan continue sikit with the written submission. Maybe saya take one slot. Ataupun masa tu you dah break into groups lah. Saya tak tahu, nanti Syami please help assist me on this. Apa kuliah akan bagi group siap-siap ke ataupun macam mana ke, saya fakulti ni nanti saya kena check. So other than that, itu saja for tonight. So maybe ada last question kalau ada.
Sir,
Syami,
berkenaan dengan kami punya assignment tadi, maaf kalau saya ada salah inform. Bila saya rujuk takwim, kami punya mid semester break is on 7 until 13 of December. So it's not next week.
Oh, I see. Saya pun tak check ke. 7
until 13 tu kami punya mid semester break.
Oh, I see. So next week ada lagi lah.
Yes.
Tak apalah, buatlah next week.
Alright, so kiranya yang
assignment tu you can still continue, tak apalah. Benda tu kan dah ada kan, dokumen semua. Buat within this week. You hantar all the draft personal exchange and then you file on Selasa. Awak nak cakap apa, Syami?
So the bundle of documents tu akan dia punya deadline dia after mid semester break ataupun next week?
Next week lah.
Next week lah.
Kalau tidak jadi 3 minggu pula. So saya ada masalah kan. Ada masalah, saya tak peduli pun, buat je lah. I mean, you betul tak? Correct me if I'm wrong. You have the documents already, right? Ya kan? Ada tak yang tak buat dokumen? You have to do kan? You kena buat affidavit. You ada affidavit the document. It just about compiling document, buat index and marking, itu saja. Kalau you kena create document, maybe I bagi the time. So kita dah masa. Bila kita dah after the break, kita dah nak start buat simulation. So before that. Alright. Dan kalau saya bagi yang ni nanti jadi panjang sangat pula, jadi sampai 2 minggu, 3 minggu pula. Tak apa. Submit next week.
Alright, sure.
Okay. And then next week we have another class. So bagus lah. So at least saya boleh habiskan about the written submission and macam mana kita nak buat oral hearing, the tips, do's and don'ts of preparing written submission. Kalau tak ada apa-apa guys, itu saja. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Thank you, sir.
Thank you, sir. Thank you, sir. Hi, Fauzan. Thank you, sir.
Thank you, sir.
Hi, Fauzan.
Thank you, sir.
Thank you, sir.
Thank you, sir.